a person who is accusing McDonald's Corporation, Tony Clark, the plaintiff, represented by the team to my left. The defense is on the other side. The defense always is there, plaintiff is always here. So, the plaintiff in this case is representing a person named Tony Clark, and they're claiming that when they went to a McDonald's restaurant, they suffered serious injuries, and they're claiming McDonald's was negligent in the way they dealt with them that day, and you're going to be hearing from the plaintiff team about that. The defense is representing McDonald's Corporation. And in every trial, as you know, there are two sides to a story. McDonald's has their defense, a very affirmative defense they're going to offer you as to why, even though they're sorry for what happened to Tony Clark, and they regret that it occurred, it's not their fault. And they are asking the court to deny damages. The word damages means, in civil law, money. There's two types of damages. There's compensatory damages to compensate a plaintiff for injuries, for example, medical bills, physical therapy, and other things. And there are also what is called punitive damages. Punitive from the word punish. The plaintiff would like you to consider punishing McDonald's Corporation for the negligent way they handled the matter when the young person came in for breakfast. Does that make sense to everyone? Now, the word negligence goes to the concept of you can be negligent in two ways. You can be negligent by something you do that causes someone harm, right? You can also be negligent by something you fail to do that you should have done that causes someone harm. And we'll find out from the plaintiff exactly what their theory is going to be as to why McDonald's should be held responsible for what happened to Tony Clark. Negligence has four elements. There's a duty to care that must be proven by the plaintiff. They have a burden here. They have to prove McDonald's had a duty to care for the customer. They have to prove that somehow they broke that duty to care by something they did or something they failed to do that they should have done. A third thing they have to prove is injury. You'll be hearing testimony, hopefully from the plaintiff, about that. And finally, the last thing is called proximate cause or cause. The plaintiff is going to claim the cause of the injuries is McDonald's negligence. The defense is going to claim concomitantly the cause of the injuries is the plaintiff's risk-taking. And the jury decision will be yours. So without any further delay, let us hear the opening statement from the plaintiff.
May it please the court.
It pleases the court. Proceed.
My name is Shane Bhatia, and along with my teammates Tony Clark and Samir Banerjee, represent the plaintiff today in court in the matter of Tony Clark versus McDonald's Restaurant Corporation. Your Honor, McDonald's has a duty to care for all customers who enter their business. McDonald's must make their restaurant both clean and a safe place to eat. On the day in question, the restaurant was clean, but we will show that it was not safe for the plaintiff, Tony Clark. McDonald's broke their duty to care for the plaintiff by serving a dangerously hot beverage with no warning provided by any of their employees. Your Honor, Tony Clark would tell this court what happened to him when he drank that hot chocolate that morning. He would tell this court about his injuries and his time spent in the burn unit of the local hospital. Your Honor, we will further show that the cause of his painful injuries was the negligence of the McDonald's staff on that day. Neither the server nor the manager warned Tony Clark about the dangerously hot beverage. We will show that there were no signs posted warning customers of the danger. We will show that although the hot chocolate was the very last item that Tony Clark drank that morning and should have had plenty of time to cool down, it was still so hot that it caused terrible burns to Tony Clark. Your Honor, we are asking this court to award $8,345 to pay for the medical bills the plaintiff owes to the hospital and $50,000 in punitive damages to serve as a lesson to McDonald's that they must provide all customers a safe place to eat. Thank you, Your Honor.
Thank you. Now, in the field of law, there are two sides to a story. In all fairness, we need to hear the defense opening statement. You may proceed.
May it please the court. My name is Rachel, and I, along with my teammate Rosabelle, represent the defendant in court today in the matter of Tony Clark versus McDonald's Restaurant Corporation. Your Honor, it is true that McDonald's has a duty to care for all its customers. We will show that McDonald's did care for the plaintiff and all other customers on the morning in question. A hot breakfast was ordered by the plaintiff, and a hot breakfast and beverage was served to the plaintiff. McDonald's served the plaintiff exactly what was ordered. An Egg McMuffin, hash browns, and a hot chocolate was served. We pride ourselves on serving hot, fresh breakfast, just like our customers like them. We did not break our duty to care for the plaintiff that morning. We don't deny that an injury occurred to the plaintiff, but we did not cause that injury. It is our belief, and we will show that the plaintiff himself caused his own injuries. We will show that he chose to gulp down that hot chocolate without first either sipping it or blowing on that hot beverage. Your Honor, the plaintiff assumed a grave risk of injury by these actions. Your Honor, we ask that the request for damages for both medical bills and punitive damages be denied by this court. It is our belief that McDonald's Corporation was not negligent in any way on that fateful morning. We hope that the plaintiff recovers from his injuries and stops by again for one of her hot and delicious breakfasts. Thank you, Your Honor.
Thank you. So I think the battleground has been set by these two excellent opening statements. Does the plaintiff have a witness in this case?
Yes.
The plaintiff calls whom? The attorney should rise and let me know the name of the witness.
Tony Clark.
Is Tony Clark in the courtroom?
Yes, Your
Please come
Honor.
forward. Raise your right hand, Mr. Clark. Please stand. You solemnly swear the testimony about to give in this matter of Tony Clark versus McDonald's Corporation heard on the 11th day of December in the year 2011 is the truth, the whole truth, and nothing but the truth.
Yes.
Please take a seat. Direct examination of Mr. Clark.
May it please the court.
Proceed.
Please state your full name for the court.
Tony Clark.
Do you remember where you were on August 16th, 2010?
I was at McDonald's on August 16, 2010.
What did you order for breakfast that morning?
I ordered hash browns, an egg McMuffin, and a hot chocolate.
What did you decide to eat first?
I ate the hash browns.
What did you eat next?
I ate the egg McMuffin.
How did they taste?
It tasted delicious.
What is the next thing that you did?
Picked up the cup and drank some hot chocolate.
What happened after you drank some of that hot chocolate?
My lips started to burn and my throat felt like it was on fire.
Did anybody come to help you?
Yes, McDonald's workers did.
How did they help you?
They called an ambulance.
Where were you taken?
I was taken to Blair Memorial Hospital, burn unit.
How long were you kept in the burn unit?
I was there for 2 full days.
How were you feeling during that time in the burn unit?
I was in a lot of pain.
Tony, did anybody at McDonald's warn you about how hot that hot chocolate was?
No, nobody did. Not the server, nor the manager. Nobody did.
Tony, can you describe the cup that the hot chocolate was served in?
Yes, it was a styrofoam cup.
Do you believe that it mattered what kind of cup was used to serve that hot chocolate to you that morning?
Yes, because it kept the drink hot.
Do you believe it mattered that the hot chocolate was the last part of your meal that morning?
Yes,
Why do you say that?
because I gave it plenty of time to cool.
Tony, do you know how much your medical bill was for your stay at Blair Memorial Hospital?
Yes, $8,345.
What are you asking this court to do?
I'm asking for $8,345 in compensatory damages and $50,000 for the negligence from McDonald's part.
Tony, is there anything else that you want to say to the court today?
Yes, I do. If I or any other customer drank that hot chocolate first, we would have all been burnt. Even worse.
I have no further questions of this witness.
Is there a cross-examination of Tony Clark?
Yes.
You may proceed.
muffin, hash browns, and a hot chocolate at McDonald's restaurant, correct?
Yes.
Was the hot chocolate served to you in a white styrofoam cup?
Yes.
Can we agree that a styrofoam cup is not hot to the touch, so customers can lift it without getting their fingers and hands burned?
Yes.
So that cup allows you to pick up a very hot beverage without getting your fingers and hands burned.
Yes.
So can we agree that just touching the styrofoam cup would not tell you how hot the beverage really was?
Yes.
Do you know that a styrofoam cup keeps beverages such as hot tea, coffee, and hot chocolate from cooling off?
Yes.
Did it have a lid on it when it was served to you?
No.
So you saw all that steam that was coming off of that hot chocolate, isn't that correct?
Yes.
You ate hash browns, an Egg McMuffin when you sat down at your table, correct?
Yes.
Then you took a big gulp of that hot chocolate, isn't that a fact?
Yes.
Tony, can we agree that there's a difference between taking a sip of a beverage and taking a big gulp of a beverage?
Yes.
You had a choice to whether to take a sip of that hot chocolate or to gulp down that hot beverage, isn't that true?
Yeah.
You chose to gulp that hot chocolate, right?
Yeah.
Is it fair to say that you could have just taken a little sip of that hot chocolate to check how hot it still was, correct?
Okay.
But you didn't just take a sip of that hot chocolate, did you?
No.
Tony, you assumed that because you ate the hash browns and Egg McMuffin first, that the hot chocolate was then cool enough to drink safely, didn't you?
Yeah.
But you were wrong, isn't that a fact?
Yeah.
It was only when you gulped down that hot chocolate that you burned your lips, tongue, and throat, correct? You believe that McDonald's should have warned you about the hot chocolate.
Yes.
Then you must also believe that McDonald's should have warned you about their cold sodas, slushies, sundaes, ice creams, and frozen yogurts. Your Honor, I have no further questions of this witness.
Redirect?
Yes.
You would like to redirect the witness?
Yes.
Please come forward.
Tony, why did you gulp that beverage?
Because I gave it plenty of time to cool while I was eating those hash browns and egg muffins that I ate.
How long did it take you to eat your breakfast?
Like 10 to 15 minutes should have cooled down.
I have no further questions of this witness.
Any recross of this witness?